Okay, we are streaming now. Nadine, can you put us on the record? All right, this is a matter of Brooks versus Brooks. Counsel, if you could each state your appearances, please.
Thank you very much, Your Honor. Donald Neville appearing on behalf of and with Ms. Bridget Brooks, who's appearing by Zoom without objection.
Good morning, Your Honor. Erica Tiranova on behalf of Wesley Brooks, who is appearing to my left, and we do not object to this hearing being held by Zoom.
All right, and I understand you wish to put a settlement or a partial settlement on the record today. So whoever wishes to do that, go ahead.
Thank you, Your Honor. There were several issues that these parties had, and we were able to narrow them today. I'm going to read into the record a proposed stipulated order that Mr. Neville and I have been working off of actually for quite some time to get this resolved. So we agree that the most recent stipulated order that I sent him is the one that we will be reading today. The changes that will occur on this order are the parenting time remains the same. I will just place the effective date since it's been quite some time of when they actually started that. And it was following the hearing on December 16th, 2019. The next paragraph that will have a change is the regarding the Christmas parenting time. That issue had originally been reserved by my client at a prior hearing for Christmas parenting time that occurred in 2018. Both parties agreed that that has been resolved and we can strike that from the proposed order. So I'm striking the sentence, the issue of defendants make up Christmas parenting time for 2018 break is reserved for further hearing. That is gone. The next paragraph is now going to read, it is further ordered that the parties will take the minor children for an opinion regarding the vaccine and allergy issue. The party shall schedule an appointment with Dr. Carissa, Orizondo. The date shall be scheduled at a time when both parties can attend either virtually or in person. Both parties understand that they may have one person present physically and one person by FaceTime, and that's agreeable. The proposed language regarding school district, the parties subsequently agreed after that hearing that the children will attend public schools. So the children will attend school beginning fall of 2021 in Manchester Public Schools. If either party decides that they want a different school, they will have to file a motion and bring that before the court since it is a joint legal custody decision. The next paragraph regarding Our Family Wizard, I'm going to change the second sentence to read, plaintiff shall be entitled to a fee waiver and shall immediately attempt to receive the service at reduced or no cost. And then the other remaining change is to the last paragraph concerning child support issue. I am going to add that this case is referred to friend of the court for a conciliation or Fig C, whatever they're calling it at this point, regarding child support. And the investigator is to use actual incomes for 2019 and 2020 to present to make a recommendation. Either party will have the opportunity to be heard on that issue if there is an objection, as well as the issue of spousal support since it's contingent on child support. And the effective date of that recommendation is going to be, just a minute, please, I'm looking it up on the ROA, is January. The motion was filed with the court on January 2nd, 2019, Your Honor. So that would be the effective date of the recommendation. That's my understanding of the agreement. I don't know if Mr. Neville has any corrections before we inquire of our client.
Well, let me make one suggestion.
Sure.
Since I'm recommending that you go the conciliation route just so that it can get resolved quicker, indicate that if the parties are unable to reach agreement on what this is, that the conciliator shall make a recommendation. Otherwise, they'll wonder why I set it up this way.
Thank you.
I have no objection to that, Judge.
Okay, Mr. Neville, with respect to the matters that Ms. Terranova put on the record, I did notice that your client had an adverse reaction to one of the things that were stated. I don't know if you picked that up or not.
I did, Judge. That's with regard to the school that we spoke to you about. You know, she's living with her parents and doesn't intend on remaining there. And so she wanted the language to be where she resided. And that's what we talked about. And it was your Honor's direction that it's where she resides now. And if she's going to move, then she can petition.
I mean, what happens if I move this summer? Like, that's my concern is if I move, I have to continue to file these motions. If I move this summer before the school year, how I can't keep coming back to try to file stuff when nothing's getting resolved.
All right, let me speak to that, ma'am. The issue is that the two of you have joint legal custody. Joint legal requires that the parties consult and reach agreement on major changes with respect to the child or children. I don't know how many children are involved here. And that's unfortunately how it works. You can't just change the school unilaterally. Now, I get the fact that you're going to want the children to be attending school where you live. It simply requires that you talk to their father and say, all right, I found a place in Saline, or I found a place in Brooklyn, or wherever. I'm assuming you're going to stay somewhere in the vicinity, and you talk about it. And hopefully it makes sense for everyone. Clearly, if you're not living in Manchester anymore, it's not in anybody's interest that you keep the kids going to Manchester, but it requires that you talk about it. And that's what has to happen no matter what. I can't give either parent a blank check to enroll the kids wherever they want to when they move. I just can't do that. That's not how joint legal custody works. And I realize if you don't reach agreement, it may require that you come back in front of me. But the reality is that's how joint legal custody works.
I appreciate the clarification, Judge, and that was her point of displeasure. I think she understands the court's position.
So with respect to the clarifications placed on the record, are we in agreement that at least as to what was placed on the record that there is agreement?
Yes, Your Honor.
Okay, I will watch for that order. I will sign it as soon as it's submitted. And hopefully with the help of this conciliator, we can get issues resolved, and hopefully these folks can stop spending money on lawyers. No offense to the lawyers, but I understand where they're coming from.
Yeah. Thank you,
Okay.
Your Honor.
Thank you, Your Honor.
You're
I appreciate
welcome.